We now know we will be hearing rulings from the Supreme Court on not 1 but 2 days this week. One decision expected before the court's term ends in late June. A verdict on the Voting Rights Act of 1965. The law is widely considered the most important piece of civil rights legislation ever passed by Congress. According to NBC's Pete Williams, if the court were to strike down part of the law, it would dramatically reduce the federal government's role in overseeing voter discrimination in a wide portion of the nation. Now, the court had come close to doing this in the past. Joining us now is Mike Sacks, who covers the Supreme Court for the Huffington Post, attorney Tom Goldstein of SCOTUSblog, which has partnered with NBC and MSNBC, Kathy Culliton Gonzalez, who is senior attorney and director of voter protection for the Advancement Project, a human rights organization. Mike, to you first here. Shelby County, Alabama, wants this to be ruled unconstitutional, and there's two parts to this.
Right. So there is Section 4B and Section 5 of the Voting Rights Act of 1965. Section 5 governs the pre-clearance provision that all covered jurisdictions, much of the South, has to go to the federal government in order to obtain permission to change a voting booth or something, anything minor. The other bit is the formula for which the federal government looks at who needs pre-clearance. And that, I think, is the one that's most likely to be scrutinized and struck down in this
And they're
case.
saying it's outdated, is what Shelby County is saying, right?
Exactly. They're saying it's based on data from several decades ago that no longer represent today's demographics.
Tom, arguing the current law is constitutional, a U.S. solicitor had said, quote, thousands and thousands of changes in people's ability to vote could be made if this law is overturned. That U.S. solicitor, what was he aiming to state, and what are some of those examples?
Well, what he's trying to do is really highlight the breadth of the court's ruling if it does say that Section 5 or that part of Section 4 are invalidated, so that local jurisdiction, for example, one in the South that has a history of discrimination, doesn't have to get pre-approval for a change in a voting system. And it could really be anything. It could be something as simple as where a polling place is, moving it out of a neighborhood, for example, that is more accessible to the minority population. It could be changing district lines. The thing about Section 5 that both is so important but also makes it vulnerable is it is incredibly broad in the range of voting systems that it applies to.
Okay, and Kathy, which states, as we talk about the broadness of this, which states would be most affected by the ruling?
States across the South and Southwest, but also parts of Alaska, parts of New York City, because they have also had a long history of discrimination in voting. And Section 5's formula actually was set to address that history of discrimination in voting. So these jurisdictions over and over and over again have enacted voting changes. They seem minor, but since its inception, it has stopped over 1,500 discriminatory voting laws. And those are voting laws like voter ID laws, poll taxes, literacy tests, proof of citizenship, show me your papers to vote, kinds of things that really do have a disparate impact on African Americans and Latinos and Asian Americans. So we know from 2012, last year, we work in voting rights. Advancement Project was actually involved in 6 voting rights cases last year. And looking at Section 5 and how important it was last year, it struck down discriminatory voter ID laws that would have stopped millions of voters of color being able to vote in Texas and in South Carolina. Mississippi didn't pre-clear its law. It decided to hold off. It stopped cuts in voter registration drives in Florida. It's really very meaningful and very much needed today. This year already, Section 5 states, there's 15 of them, 12 of them have already begun to consider new discriminatory voting laws. So it's not as if, the battle for voting rights and the long, hard war in civil rights that people marched and gave their lives for is over. We know last year and this year there are voting rights laws that these states try to enact that would make it harder for African Americans and Latinos and Asian Americans to vote.
Mike, you're reporting. Have you found the same to be true based on what she said there?
Well, the covered jurisdictions, they all think it's incredibly cost prohibitive for them to go to the federal government and say, hey, this is, you really want us to do what you're saying, you really want us to change everything prophylactically, it just costs too much for us. But the flip side of what's going on is that if Section 5 or Section 4B gets struck down, then what remains of the Voting Rights Act is Section 2, which requires any plaintiff or allows any plaintiff to nationwide sue anyone that's making what they say is a vote diluting or discriminatory voting practice. And in doing so, the states, the municipalities, the counties, the governments that are being challenged will still have to spend a lot of money. We'll also have to do a good amount of defense work to make sure that they are scot-free when it comes to voting.
Is that the major economic impact, what you're talking about, just the legal processes that will then come into play?
Yeah, and ultimately it depends on who's going to be paying it up front. Is it going to be a plaintiff who's saying this is discriminating against me, or is it going to be the state that has to go to the federal government and prove that their practices are not discriminatory?
Okay. Kathy, have there been certain minority groups that are more vocal than others about protecting the law, as you've heard so far?
No, Advancement Project is a multiracial organization, and we've actually worked on behalf of African Americans and Latinos and Asian Americans, and I know other groups have worked extensively with the Native American community. So we are all in a strong coalition together and making sure to try to protect Section 5. We're waiting with bated breath to see what happens with this decision and another decision coming out of Arizona. And I wanted to add, these states actually could bail out of Section 5 or 4B coverage very easily. I used to work for the Department of Justice in the voting section. All they have to do is prove that they have not discriminated within 10 years. And then the Department of Justice bails them out, so they would no longer be covered, so they would no longer have to submit their voting changes for preclearance. And on the other hand, the groups like our nonprofit group who have to do would have to do Section 2 litigation or would have to use other legal tools, we're certainly not going to give up. But that's very cost prohibitive for us and for the jurisdictions and for voters. These are our most fundamental rights, and certainly voters of color are concerned, but all Americans are concerned about this assault on voting rights and why in the world the Supreme Court would think that the Voting Rights Act is no longer needed.
Well, this might be part of it. Tom, to you, according to Pew, in the past 3 presidential elections, few Americans reported problems or difficulties in voting. Some of the numbers that we've got coming from Pew for the 2012 election, when asked, did you have any problems or difficulties voting this year? When asked that question, just 4% of white voters said yes, and only 2% of African-American voters said yes. So small numbers there. How are those numbers different in the states affected by this law?
Well, I don't know that the numbers that would get reported in a poll are different. I think civil rights advocates would say this is a lot more subtle than someone being excluded right at the door of the voting booth, for example. They're talking about changes in poll locations, changes in lines, but the polls do, I think, drive in part the Supreme Court majority. Its fundamental point is, look, it's been decades since these jurisdictions were originally identified. Congress needs to update that list because it's operating unfairly on a lot of the country that doesn't engage in that kind of discrimination.
Quickly to all 3 of you. Tom, what do you think the outcome's going to be?
I think that the statute's going to get struck down. I'm sorry to say that for civil rights advocates, but this court signaled several years ago it had real concerns about the law.
Mike?
Yep. Court said Congress fixed this 3 years ago. Congress didn't fix it. Court will this time strike down the preclearance provision or the formula Congress uses. Congress won't do anything about it, and we're not going to see this come back.
Okay, and to you, Kathy.
We are hoping for a win. We're still hoping for a win. You never know until the court makes its decision. And as Justice Sotomayor said, Shelby County, Alabama, which has recently discriminated in voting, is not a good plaintiff. And so we don't think that this is, the case that justices like Justice Kennedy would want to make their legacy on in order to strike down one of the most important civil rights protections in our nation's history. So we're hoping for a win. We'll see what happens.
Kathy, Tom, Mike, thank you so much for your perspectives today.
Thanks very much.
Thank you.